Let's enter a chapter that bridges two worlds many of you already care deeply about: data privacy and AI. The key insight here is that existing privacy laws don't disappear when AI arrives. They apply, often in challenging new ways. So here's what we'll explore together. We'll start with the obligations privacy laws place on AI systems, things like privacy notices, meaningful choice, and consent, including the tricky question of consent for AI purposes. Then we'll wrestle with the genuine friction points like automated decisions, lawful basis, purpose specification, and what counts as compatible use. From there, we'll look at core privacy principles applied to AI, data minimization in training, privacy by design, and impact assessments. And we'll finish with the operational realities, managing third-party processors, handling cross-border data transfers, and keeping proper records. Here's how I want you to approach this. Don't think of privacy law as a separate topic bolted onto AI. Think of it as a lens you carry into every AI system asking, how do the privacy rules we already know apply to this new technology? Because for those of you with a privacy background, this is where your existing expertise becomes a real superpower. Let's begin. Let's start with something foundational in privacy law that takes on new complexity with AI: privacy notice obligations. Here's the principle applied to our context. Privacy laws generally require organizations to tell people how their personal data is being collected and used through a privacy notice. When AI is involved, that obligation continues, but it gets harder to fulfill well. Why harder? Let me explain. Traditional privacy notices describe straightforward uses. We collect your email to send you updates. But AI uses can be complex, opaque, and far-reaching. How do you clearly explain to someone that their data will train a model that makes predictions in ways even the developers can't fully describe? That's the challenge. Let me give you an example. Imagine a company using customer data to train an AI that personalizes services. A good privacy notice must explain this in a way people can actually understand, not bury it in dense legalese. But here's the tension. AI's complexity makes plain explanation genuinely difficult. The obligation to be clear collides with the reality that AI is hard to explain. Have you ever read a privacy notice and understood nothing? Now imagine that problem amplified by AI's opacity. Here's the governance lesson. Privacy notice obligations require organizations to be transparent about AI's use of personal data, even when that's challenging. The goal is meaningful transparency, helping people genuinely understand, not just technically disclosing in fine print. As a professional, always ask, does our privacy notice actually tell people in understandable terms how AI uses their data? Because transparency is the foundation of trust and a legal requirement. With AI, meeting it well takes real effort, but that effort is exactly what responsible, lawful AI demands. Let's explore a cornerstone of privacy, giving people meaningful choice and consent, and how AI complicates it. Here's the principle. Privacy laws often require that people have a genuine choice about how their data is used, and in many cases, that they give consent. The word that matters most here is meaningful. The choice has to be real, not an illusion. Let me explain why this gets tricky with AI. Consent is only meaningful if people understand what they're agreeing to and have a real option to say no. But remember our last discussion, AI uses are complex and hard to explain. So how can consent be truly informed if the person can't really grasp what the AI will do with their data? Let me give you an example. Imagine an app that asks you to consent to your data being used for AI-driven personalization. You tap agree without really understanding what that means because the explanation was vague and the only alternative was not using the app at all. Was that meaningful choice or just a box-ticking exercise? Here's another wrinkle. Sometimes consent is bundled. You must agree to everything to use the service. Is that a real choice or coercion dressed up as consent? Privacy law increasingly scrutinizes exactly this. Here's the governance lesson. Meaningful choice and consent mechanisms require that people genuinely understand and freely decide, which AI's complexity makes harder to achieve honestly. The goal is real agency, not manufactured agreement. Let's go deeper into consent with a more specific and important idea: granular consent for AI purposes. This addresses a subtle but significant privacy challenge. Here's the concept. Granular consent means giving people the ability to consent to specific uses of their data separately rather than forcing an all or nothing agreement. Applied to AI, it means letting people agree to some AI uses of their data while declining others. Why does this matter so much with AI? Let me explain. Organizations often want to use data for multiple AI purposes, perhaps improving a service, training new models, and personalizing ads. Bundling all of these into one blanket consent denies people real control. Granular consent restores that control by separating the choices. Let me give you an example. Imagine a service that uses your data in several ways. With granular consent, you might happily agree to it being used to improve your own experience, but decline to have it used for training a general-purpose model that benefits the company more than you. You get to draw that line yourself. Isn't that a more respectful approach than take it or leave it? Here's why this connects to AI specifically. AI's many possible uses of data make bundled consent especially problematic because the uses can be so different in their implications for the individual. Training a model that retains your data forever is quite different from a one-time personalization. People deserve to treat those differently. Here's the governance lesson. Granular consent for AI purposes respects that people may feel differently about different uses of their data and gives them control accordingly. It's about precision and respect, not blanket permission. Let's confront one of the most significant privacy concerns in the AI era: the challenges with automated decisions made by AI. This is an area where privacy law and AI collide head-on. Here's the issue. Many privacy frameworks give people special protections when decisions about them are made automatically, without meaningful human involvement, especially decisions with significant effects on their lives. AI makes such automated decisions common, and that raises real challenges. Why the special concern? Let me explain. Imagine a decision that seriously affects you, whether you get a loan, a job, or a benefit, being made entirely by a machine with no human judgment and no clear explanation. That feels unsettling, doesn't it? Privacy law recognizes this, often granting rights like the ability to contest such decisions or demand human review. Let me give you a concrete example. Suppose an AI automatically rejects someone's loan application. Privacy frameworks may require that the person be informed this was automated, be given some explanation, and have the right to request a human to review it. But here's the challenge. Remember the black box problem? If the AI's decision can't be easily explained, how do you provide a meaningful explanation or a genuine human review? Here's another tension. Truly meaningful human involvement isn't just rubber stamping the AI's decision. If a human just clicks approve on whatever the AI says, is that real oversight? Privacy law increasingly says no. Here's the governance lesson. Automated decisions challenge us to provide transparency, explanation, and genuine human oversight, exactly where AI's opacity makes those hardest. The protections exist because automated decisions about people's lives carry real risk of unfair, unexplained harm. Let's examine a fundamental requirement of privacy law and how it applies to AI: having a lawful basis for processing personal data. This is bedrock, so let's understand it well. Here's the principle. Many privacy laws require that you have a valid legal reason, a lawful basis, to process someone's personal data. You can't just use data because it's convenient. You need a legitimate justification recognized by law, such as consent, a contract, a legal obligation, or a legitimate interest. How does AI complicate this? Let me explain. AI often involves using data in new ways, sometimes ways not anticipated when the data was first collected. So the question becomes, do we have a lawful basis for this particular AI use or only for the original purpose? Let me give you an example. Imagine a company collected customer data to provide a service with a lawful basis for that. Later, they want to use that same data to train an AI model. Is the original lawful basis still valid for this new purpose? Maybe not. They may need to establish a fresh lawful basis, or they could be processing unlawfully. Here's another nuance. Different lawful bases carry different obligations and limits. Relying on consent, for instance, means people can withdraw it. Relying on legitimate interest requires balancing the organization's interest against people's rights. Choosing and justifying the right basis for AI use takes genuine care. Here's the governance lesson. In AI contexts, you must ensure there's a valid, lawful basis for each way you process personal data, especially for new AI uses that go beyond the original purpose. You can't assume old permissions cover new AI ambitions. As a professional, always ask, what's our lawful basis for using this data in this AI system, and does it actually hold up? Because processing personal data without a proper lawful basis is a fundamental privacy violation. With AI constantly finding new uses for data, checking that you have solid legal ground for each one is essential to staying lawful and trustworthy. Let's explore a principle closely tied to lawful basis, purpose specification, and how it shapes AI use. This principle is more powerful than it first appears. Here's the idea. Purpose specification means that when you collect personal data, you should clearly define and state the specific purposes for which you'll use it. You can't just collect data for vague, open-ended reasons. You specify why upfront. Why does this matter so much for AI? Let me explain the tension. AI thrives on data, and organizations are often tempted to collect data now and figure out uses later. The more data, the better, just in case. But purpose specification pushes directly against that, requiring you to know and state your purpose at collection time. See the conflict? Let me give you an example. Imagine a company that collects data saying it's for improving our services. Then they decide to use it to train a powerful new AI model for an entirely different purpose. Was that covered by the original specified purpose? Probably not. It's too vague or too different. They specified one thing and did another, which violates the principle. Here's why this protects people. Purpose specification ensures people know what they're signing up for and limits organizations from quietly repurposing data for things people never expected. It's a guardrail against function creep, where data slowly gets used for more and more without anyone agreeing to it. Here's the governance lesson. Purpose specification requires defining clear, specific purposes for data at collection, which constrains how that data can later feed AI. Vague purposes or after-the-fact repurposing undermine both the law and people's trust. As a professional, always ask, was the AI use of this data within the specific purposes originally stated? Because purpose specification is what keeps data use honest and bounded. In a world where AI constantly tempts organizations to do more with data, respecting the original specified purpose is a crucial discipline and often a legal requirement. Let's build directly on purpose specification with a nuanced and practical concept: the distinction between compatible and incompatible uses. This idea gives you real guidance for tricky AI situations. Here's the concept. Privacy law often allows using data for a new purpose if that new purpose is compatible with the original one for which it was collected. But if the new use is incompatible, you generally can't do it without a fresh basis or consent. So the key question becomes, is this new AI use compatible with the original purpose? Let me explain what compatibility means in practice. A compatible use is one that's closely related to and consistent with what people would reasonably expect given the original purpose. An incompatible use is a significant departure, something people wouldn't have anticipated and might object to. Let me give you an example to make this concrete. Imagine data collected to process customer orders. Using it to improve the order system, arguably compatible, people would expect that. But using that same data to train an AI that profiles customers and sells insights to advertisers? That's likely incompatible, a major departure from the original purpose that customers never expected. Do you see how the line gets drawn? Here's why this matters for AI. AI tempts organizations toward ambitious new uses of existing data, and the compatibility test is a key check on whether those uses are actually permissible. It forces an honest assessment. Would people reasonably expect this, given why we originally collected their data? Here's the governance lesson. The compatible versus incompatible distinction helps you judge whether a new AI use of existing data is allowed based on its relationship to the original purpose and people's reasonable expectations. It's a practical tool for navigating data reuse responsibly. As a professional, always ask, is this AI use compatible with why we originally collected the data, or is it a step too far? Because respecting this boundary protects people from having their data quietly turned to purposes they never agreed to. It's one of the most useful tests you can apply when AI ambitions meet existing data. Let's tackle a privacy principle that directly challenges one of AI's core tendencies, data minimization, specifically in the context of training models. This is a genuine tension worth understanding deeply. Here's the principle. Data minimization means collecting and using only the personal data you actually need for your purpose, no more. The idea is simple. Less data means less risk, so don't hoard data you don't truly require. Now here's the head-on collision with AI. AI, especially modern models, often performs better with more data. So there's a powerful pull toward gathering as much data as possible. Data minimization pushes the opposite way. Use only what's necessary. These two forces are in direct tension, and navigating it is a real governance challenge. Let me give you an example. Imagine a team building an AI model who think, let's include every piece of customer data we have, just in case it helps. Data minimization says, no, only use the data genuinely needed for this specific model and purpose. The team must justify what they actually need rather than grabbing everything. Have you noticed how the instinct with AI is always more data, more data? Minimization is the deliberate discipline that resists that instinct. Here's why this matters beyond compliance. More personal data in a training set means greater privacy risk, a bigger breach if something goes wrong, more potential for misuse, and harder compliance. Minimization reduces all of that. It's not just legal, it's genuinely safer. Here's the governance lesson. Data minimization in AI training requires using only the personal data truly necessary, even when more data might improve performance. It's about balancing capability against privacy risk and erring toward restraint. As a professional, always ask, do we actually need all this personal data for the model? Or are we collecting it just because we can? Because every piece of unnecessary personal data is a liability waiting to cause harm. Practicing minimization, even against AI's hunger for data, is a hallmark of privacy-respecting, responsible AI development. Let's explore a principle that should sound familiar in spirit: privacy by design and by default applied to AI. This is one of the most powerful proactive privacy concepts there is. Here's the idea. Privacy by design means building privacy protections into a system from the very start, as a core part of its design, not an afterthought. Privacy by default means the system should automatically protect privacy without the user having to do anything. The most privacy-friendly settings are the starting point. Does this remind you of ethics by design from an earlier chapter? It should. It's the same proactive philosophy focused on privacy. The best time to protect privacy is when you're designing the system, not after it's built. Let me give you an example. Imagine a team building an AI feature. With privacy by design, they consider from day one how to minimize data, how to protect it, and how to give users control, weaving these into the architecture itself. With privacy by default, when a user starts using the feature, the privacy protective settings are already on, rather than the user having to hunt through menus to turn them on. Compare that to the all-too common opposite, a system built first with privacy bolted on later, and default settings that expose data unless the user actively changes them. Which approach actually protects people? Clearly the first. Here's why this matters, especially for AI. AI systems are complex and data hungry, so retrofitting privacy is even harder than usual. Designing it in from the start and defaulting to protection is far more effective. Here's the governance lesson. Privacy by design and by default ensure privacy is foundational and automatic, rather than optional and easily overlooked. They put the burden of protection on the system, not the individual. As a professional, always ask, was privacy built into this AI from the start? And do the default settings protect people automatically? Because privacy by design and default is how you make privacy reliable rather than dependent on luck or user effort. It's proactive protection. And with AI's complexity, that proactive stance matters more than ever. Let's look at a specific structured tool for protecting privacy in AI, the Privacy Impact Assessment, often called a PIA or DPIA. You'll work with these often, so let's understand them well. Here's the concept. A privacy impact assessment is a structured process for evaluating how a project, like an AI system, affects people's privacy, identifying the risks, and figuring out how to reduce them. A DPIA, Data Protection Impact Assessment, is a specific form required under some privacy laws for higher risk processing. Does this remind you of the impact assessments we discussed earlier? It should. This is the privacy-focused version, zeroing in specifically on privacy risks. When is one needed? Let me explain. For AI systems that process personal data in significant or risky ways, especially high-risk ones, privacy law often requires a DPIA before you proceed. It's a mandatory look before you leap for privacy. Let me give you an example. Imagine a company planning an AI system that profiles individuals using lots of personal data. A privacy impact assessment would systematically ask, what data are we using? What privacy risks does this create? Who could be harmed? And how do we mitigate those risks? Doing this before deployment lets them fix problems proactively rather than discovering them through a privacy disaster. Here's why this is so valuable. The assessment forces a thorough, documented examination of privacy risks at the right time before harm occurs, and the documentation itself demonstrates due diligence to regulators. Here's the governance lesson. Privacy impact assessments are how we systematically identify and address privacy risks in AI before deployment, and they are often legally required for high-risk uses. They turn vague privacy concerns into a concrete, actionable analysis. As a professional, always ask, does this AI system need a privacy impact assessment? And have we genuinely conducted one? Because for any AI that significantly touches personal data, assessing the privacy impact in advance is both a legal safeguard and a practical way to prevent harm. It's one of your most important tools for embedding privacy into AI responsibly. Let's address a practical privacy reality in the AI world: managing third-party processors who handle personal data on your behalf. This connects privacy law to the vendor relationships we discussed earlier. Here's the concept. In privacy terms, a processor is a party that handles personal data on behalf of another organization, the controller, following its instructions. With AI, organizations frequently use third-party processors, cloud providers, AI vendors, data services who touch personal data as part of delivering AI. Why does this require careful management? Let me explain a crucial principle. Even when you hand data to a processor, you, as the controller, generally remain responsible for that data. You can't just pass data to a vendor and wash your hands of it. So you must ensure those processors handle it properly. Let me give you an example. Imagine a company using a third-party AI service that processes its customers' personal data. The company is still responsible for ensuring that data is protected, used only as instructed, and handled lawfully, even though the processor is doing the actual work. If the processor mishandles it, the company is on the hook. So how do you manage this? Through careful selection, clear contracts specifying how data must be handled, and ongoing oversight. This connects to the third-party contracts we discussed, here applied specifically to privacy. The contract must lock down data protection obligations. Here's a question to sit with. If you give personal data to an AI vendor, do you actually know how they're using and protecting it? Many organizations don't, and that's the risk. Here's the governance lesson. Third-party processor management ensures that personal data handed to vendors is still properly protected, because your responsibility as controller doesn't disappear when the data leaves your hands. Let's explore a complex but increasingly important privacy topic: cross-border data transfers, and why AI makes them especially relevant. Here's the concept. Cross-border data transfer refers to moving personal data from one country to another. Many privacy laws restrict this because data might lose its protections when it crosses into a country with weaker privacy rules. So there are specific mechanisms required to transfer data legally across borders. Why is this so relevant to AI? Let me explain. AI often operates globally. Cloud servers in different countries, AI vendors based abroad, models trained on data from around the world. So personal data frequently crosses borders in AI systems, sometimes without anyone fully realizing it. That triggers these transfer rules. Let me give you an example. Imagine a company whose AI service stores and processes customer data on servers in another country. That's a cross-border transfer, and it must be done using a legally recognized mechanism, or the company is violating privacy law. The data physically moving across a border brings legal obligations with it. Here's what makes this tricky with AI. The global, distributed nature of AI infrastructure means data can flow across borders in ways that aren't obvious. You might use an AI tool without realizing the data is being processed overseas. So part of governance is actually understanding where your data goes. Have you ever stopped to ask where, geographically, your AI system processes data? Many people never do. Here's the governance lesson. Cross-border data transfer mechanisms are the legal tools that allow personal data to move between countries while maintaining protection, and AI's global nature makes them frequently necessary. Using the proper mechanism is essential to lawful international data flows. Let's close this chapter on privacy and AI with a requirement that underpins everything else: record keeping and documentation. It may not be glamorous, but it's absolutely essential for privacy compliance. Here's the idea. Privacy laws often require organizations to maintain records of their data processing activities: what data they hold, why, how it's used, who it's shared with, and how it's protected. With AI, these record-keeping requirements continue and often expand given the complexity involved. Why is this so important? Let me explain with a principle we've touched on before. If you can't show what you did, you can't prove you complied. Privacy regulators increasingly expect organizations to demonstrate accountability, and records are how you do that. Without them, even good practices are invisible and undefendable. Let me give you an example. Imagine a privacy regulator asks a company to explain how its AI system uses personal data, what lawful basis applies, and how risks are managed. The company with thorough records can answer clearly and demonstrate compliance. The company without records is exposed, unable to prove it did anything right, which regulators often treat as a violation in itself. Here's why AI raises the stakes. AI systems are complex, data flows are intricate, and uses can evolve. Good record keeping is what lets an organization actually understand and account for what its AI is doing with personal data. It connects to the data lineage idea from earlier, knowing the full story of your data. Here's the closing governance lesson. Record keeping and documentation requirements ensure organizations can demonstrate accountability and compliance for how AI uses personal data. They are the evidence that turns good intentions into provable practice. As a professional, always ask, are we keeping proper records of how this AI processes personal data? Because in privacy law, accountability must be demonstrable, not just claimed.